All right, let's just dive right into this explainer. We're going to explore how one man's old debt literally reshaped the architecture of digital privacy across the entire globe. I mean, what we are looking at today is a massive, foundational shift in how the internet actually operates. We're going to unpack the exact case that forced the world's biggest search engines to do something they were never designed to do: forget.
Now, to really understand this, we have to look at the striking asymmetry of digital memory. This whole global movement started with a deeply personal story involving a Spanish man named Mario Castello Gonzalez. Back in 2009, Mario did what, pretty much all of us have done at some point. He Googled his own name. But what popped up completely ruined his digital reputation. The machine simply refused to forget a piece of his past. And that stubborn digital memory, well, that is exactly what we are going to dissect today.
Section 1. The Unforgettable Debt.
So, let's look at the timeline here. Way back in 1998, a newspaper called La Vanguardia published a brief, standard notice about a debt auction on Mario's home. The absolute crucial thing to know here is that Mario's debt was fully resolved shortly after that 1998 publication. The case was completely closed, done, dusted. Yet, when Mario searched his name on Google over a decade later in 2009, that 1998 newspaper notice was still the very first thing people saw. Every single time someone searched for him, they saw the beginning of a negative story without ever seeing the ending. It actually took until 2014 for the Court of Justice of the European Union, the CJEU, to issue a landmark ruling on this.
Think about the core harm we're dealing with. Physical records naturally decay, right? They get lost or they get stuffed into some dusty filing cabinet that nobody ever opens. But digital records, they are permanent. They are perfectly retrievable forever. Like the quote says, the default condition of digital information is perpetuity. The internet had no idea Mario's story actually had a happy ending. It just kept serving up the worst moment of his financial life on an endless loop. And this perpetuity, it causes a specific kind of harm that just didn't exist at scale before the internet came along.
Which brings us to our next section: de-indexing versus deletion.
Here's the really fascinating point. Mario didn't actually sue the newspaper, La Vanguardia, for deletion. That might actually surprise you. But the newspaper was just doing legitimate journalism. That original record of the auction was completely accurate and lawful. Instead, Mario sued Google for de-indexing. He wasn't asking for the 98 article to be wiped from the newspaper's archive. He was asking for Google to stop linking to it and blasting it to the world. His argument was that the aggregation and perpetual accessibility of that record caused him a level of harm that completely outweighed the public interest in keeping it so easily findable.
Grasping this distinction is absolutely vital. We're talking about erasure from search, not erasure from history. After the ruling, that 1998 article, it still existed, and honestly, it still exists today. But confusing these two concepts, deletion versus de-indexing, is exactly where most modern privacy compliance programs completely fail today. A lot of people think the right to be forgotten means wiping history clean. It doesn't. It really just means disconnecting the algorithmic megaphone.
Moving on to Section 3, the first result problem.
Let's put this into perspective. Before the internet, if you wanted to find a 15-year-old newspaper article about someone's resolved debt, you'd have to know it existed in the first place, know exactly which paper ran it, physically travel to a library, and manually hunt through microfiche. That high friction, it acted as a form of de facto privacy. But the internet eliminated that friction entirely. What used to require serious legwork now takes a two-word Google search. So the harm wasn't merely that the information existed. The harm was that the internet stripped away the friction, making the data effortlessly, permanently, and universally accessible the exact second someone typed his name.
This leads us to a massively important concept called contextual integrity. An innocuous, legally required notice in a 1998 newspaper archive is perfectly fine in its original context, but it suddenly becomes incredibly harmful when a search engine algorithm decides it should be the absolute first result associated with your name. The right to be forgotten is, at its core, a right to contextual integrity. It dictates that information should be available for purposes appropriate to its original context, rather than forcefully stripped of that context and blasted globally as your definitive digital identity.
Let's look at Section 4. When truth violates privacy.
So, can perfectly accurate, lawfully published, and historically verifiable information actually violate your privacy? It seems kind of contradictory, doesn't it? But the answer is yes, it absolutely can. And here's why. Under EU privacy law, accuracy is a necessary condition for processing data, sure, but it is not the only condition.
Just because something is true, perfectly accurate, and lawfully published doesn't automatically mean a massive tech company has the right to permanently attach it to your digital footprint forever. The law doesn't just ask, is this true? It asks, is it necessary, proportionate, and consistent with the original purpose for which it was collected?
To address this, the Court of Justice of the European Union made a seismic, highly contested ruling in 2014. They basically declared that search engines aren't just neutral pointers innocently directing traffic. No, when a search engine crawls, indexes, and presents information, it is performing operations on personal data. Therefore, the court officially designated search engines as data controllers. And as data controllers, they bear independent legal obligations to protect personal data, completely separate from the original publisher. They are legally responsible for the downstream effects of permanently and prominently surfacing outdated information.
Just look at the stark contrast in purpose here. In 1998, the newspaper was fulfilling a legal requirement, giving public notice of a legal proceeding. Fast forward to 2009, and Google is surfacing that exact same notice for an entirely different reason: general information retrieval. The court found that Google's new purpose was completely insufficient to override Mario's privacy interests, especially given how much time had passed since that original debt auction. Basically, the original purpose had expired, making the new processing unlawful.
Now, as you can probably guess, free speech advocates called this dangerous, while privacy advocates called it long overdue. And you know what? Both were partially right. This ruling was incredibly controversial because it created massive structural tensions. It essentially forced a private tech company, rather than a judge or a government body, to adjudicate competing rights, free speech versus privacy, at a staggering daily scale. Practically overnight, Google had to build a review process for thousands of takedown requests every single day. There was no exact legal playbook telling them exactly how to weigh journalism against privacy in every nuanced case. They just had to make those calls themselves, operating under a really heavy regulatory threat. Which brings us to our final section, a global privacy movement. The Google Spain ruling proved something that privacy advocates had been arguing for years. Search engines wield immense power over individuals' reputations and life opportunities, and that power absolutely needs legal accountability. Once that argument won in the highest EU court, it triggered a massive regulatory domino effect. Regulators all around the world saw the ruling and started asking, hey, do our own citizens deserve the right to limit how their information is aggregated? This led directly to Article 17 of the GDPR in Europe, the CCPA in California, Brazil's LGPD, and India's DPDPA. Literally, an entire global legal ecosystem grew from this one single case. So we come back to this central tension. The architecture of trust on the internet has fundamentally changed. I really hope this explainer has given you a fresh perspective on the hidden mechanics of your own digital footprint, the critical difference between deletion and de-indexing, and the ongoing battle for contextual integrity. As our lives become increasingly digitized, I want to leave you to ponder this. In a world of infinite memory, who truly owns the rights to your past? Thanks so much for joining me, and keep asking the big questions.